High Criminal Court in Croatia and European Judicial Network contact point, Tanja Pavelin. So Tanja will going to join us via Zoom. So Tanja, the floor is yours.
Thank you. So hello everybody. From our chat box, I see we have a sunny weather everywhere. So and I hope you will enjoy this conference. So I will start right away with sharing my PowerPoint. I hope you can see it. Okay, so I'm Tanja Pavelin. I'm a judge and contact point, and I work on High Criminal Court of Republic of Croatia. I will be presenting you our jurisprudence and statistics from the county court in Zagreb. I worked there. I was also NGN contact point there and the president of the panel that dealt with all the files from the field of judicial cooperation in criminal matters. First, I will give you some statistic data about the Council Framework Decision 909. We, Croatia, as the issuing state, we issued only 2 certificates so far, and both certificates had been issued on a request of the sentenced person. But when we talk about Croatia as the executing state, we received 70 judgments, and most of them are positively solved. We had 10 refusal cases, but half of them were partially refused. What is the practical problem with our law is that we have a criminal code and we have code for minor offenses, and that is not part of our criminal procedure. So often we receive judgments from other states that have more offenses, and very often some of those offenses are not part of our criminal code, but are part of other minor offenses code. So we cannot execute this judgment, and then we try to reach an agreement with that state, and we change the sentence, and sometimes we don't reach an agreement. So those refusals are mostly because of that. The Council Framework Decision 947, we issued 9 certificates so far, and all of them were about community service. Also, we issued them on the request of the sentenced person, and we executed only 1 certificate so far. It is also about the community service. What are the main conditions for recognition when we talk about 909? And that is also sometimes the main problem. The main condition is that we need to check the double criminality rule, as Croatia has submitted the declaration that we don't have a list of offenses as we have for the European arrest warrant. So we have to check double criminality in every file. Other conditions are the same as in the framework decision. So the main reason when we do not recognize the foreign judgment is that we don't find double criminality. We don't meet the double criminality condition. Sometimes, and that's in a few less cases, is that we don't have the consent of the Ministry of Justice, or that we don't have an active residence of the person. In the practice, the one of also main problems is the jurisprudence of our Supreme Court, and that is about deportation. So our Supreme Court gave an explanation about the deportation, that this deportation must be clearly stated in the judgment that the person is to be deported in Croatia. But we receive judgments, and in the judgments we don't have clearly stated in Croatia. We do have deportation measure, but without saying exactly that the person will be deported to Croatia. When I was on the County Court of Zagreb as first instance judge for those files, I would execute this judgment by explaining that we do have deportation measure, and it's logical that this person will be deported to Croatia as he is Croatian national and has residence in Croatia. But from the Supreme Court judgment, they said that this is not enough, and that it must be stated clearly that this measure is saying this person will be deported to Croatia. Sometimes we have problems with the content of the certificate. We ask for the explanation or Croatian translation, and we give a 7 days period for the issuing state to clarify what is not clear from the certificate. So if we connect this with the double criminality rule, you can see that this certificate must be well translated and must have all the facts of the offense, because we need to check double criminality in each case. Sometimes this deportation measure is not part of the verdict, and this measure is part of some other decision that is brought in another proceeding or administrative proceeding. Then we need to ask for this decision to be translated, because we search then in this decision if it's somewhere stated that the person will be deported to Croatia. In some decisions we find it, and in some decisions it's only explained about the deportation, but not saying that this deportation is to Croatia. Also, we have problems with counting the detention period, because we have detention in months, and when we give a sentence, we give a sentence in months and years, and the detention period and sometimes the sentence is in days. That is often a problem, as we have to count those days into months and years. Some countries have 30 days, some countries 41, sometimes 29, so it's quite unclear how to reach the exact time of detention or the sentence. But then we ask the issuing state to clarify that or to give us in months. And if we talk about the years, then of course it's easier. Against the first instance decision, we have the right to appeal. So before it was Supreme Court, and now it's to the High Criminal Court of the Republic of Croatia. And the time limit to decide on the appeal is 15 days. Also, what I think is interesting is the defense counsel. We in Croatia, it's not clearly stated that this person has a right to have a defense counsel ex officio. So how do we do that? If we have a judgment from the municipal court, or if we have a judgment for lower criminal offenses, and by our Criminal Procedure Act, accused will not have right to a defense counsel ex officio, then we do not give him a defense counsel ex officio. But if we receive a judgment for heavier criminal offenses, and for the offenses that under our Criminal Procedure Act, this person would have right to a defense counsel ex officio, then we also appoint a defense counsel ex officio. So on one hand, we have a defense counsel ex officio, and on the other hand, we have attorney's office, prosecutor's office. So very often, because we appoint a defense counsel ex officio, we of course have an appeal on our decision. What is the link between European arrest warrant and the recognition of sentence of foreign judgment? Is that, as I said, under the European arrest warrant, we have a list of offenses, and we do not check double criminality for those offenses. So when we accept European arrest warrant, and if that wanted person is Croatian national, then we ask for the guarantee that this person will be returned to Croatia to execute the sentence. So under the EAW, we say, okay, we are giving you this wanted person. We don't check double criminality because you checked its offense from the list. And then when the sentence and the verdict is final, and the wanted person wants to come to Croatia to serve the sentence, and that is guaranteed in a way to him, then when we receive a judgment, we have to check double criminality. So I think in Croatian law, this is the problem, and we should have the same standards for the European arrest warrant and for Framework Decision 909. And it would be much easier if we implemented this list of offenses for 909 as well. So this is the building of our High Criminal Court and County Court. Now it looks on this picture better, but now the situation is worse because we had a big earthquake and the building is really damaged. But this is the picture before the earthquake. If you have any questions, I don't know if it's possible to ask questions now, but if you have any questions, I hope you will be active and ask whatever you want. Thank you.